Tampering with a government record. What does it mean? Is there a way to win your case? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about the subject or the crime of tampering with a government record. There's a lot of misunderstandings about what this actual crime is. Is it a felony? Is it a misdemeanor? We'll go over from A to Z the basics of this crime, and I'll also provide a few defenses so you can have an understanding. Maybe you or a loved one is going through this allegation and you need this help. We'll be happy to give it to you today, okay? By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, tampering with a government record. Now, I'm going to talk about this in relation to Texas law. Texas criminal law has some very specific elements that have to be proven beyond a reasonable doubt by the state of Texas in order to substantiate this type of crime. Now, where you're going to want to look, if you want to do your own independent research, go look under the Texas Penal Code section 37.10. Under that, you'll find under that penal code section, it states that the government must prove beyond a reasonable doubt these elements of the offense, okay? A person commits an offense if he knowingly makes a false entry in or false alteration of a governmental record, makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent that it be taken as a genuine governmental record, that's the next part, or intentionally destroys, conceals, removes, or otherwise impairs the verity, legibility, or availability of a government record, possesses, sells, or offers to sell a governmental record or a blank governmental record form with intent that it be used unlawfully. Notice there's all these different variations, okay? Not trying to beat you down. You go back and look at it in the code if you want. Or makes, presents, or uses a governmental record with knowledge of its falsity, or possesses, sells, or offers to sell a governmental record or a blank governmental record form with knowledge that it has been obtained unlawfully. Now let's break all that down. First thing I want to do is, notice I gave you all of these possibilities for how that charge can come about with tampering with a government record. Let me give you a few specifics as to how Texas law punishes that crime. What distinguishes it? What makes it a felony? What makes it a misdemeanor? Now, under many circumstances, tampering with a government record can be classified as a Class A misdemeanor, punishable by a term in jail of up to 1 year in the county jail and up to a $4,000 fine. Now, if the district attorney's office alleges that you acted or you or a loved one acted with, quote, the intent to defraud or harm another, it can be elevated to a state jail felony, which is the lowest level of felony. However, it's still punishable by a minimum of 180 days in jail, up to a 2-year prison sentence, and up to a $10,000 fine. Now, it can also be punishable, because here's what your questions are. Number one, what kind of government record was it? That's the first question you want to ask. Probably kind of getting ahead of myself here. First thing is, if you came into my office and asked me about your situation, I'd want to know what kind of record it was, okay? Then the second thing is, was that record used in some way to harm or defraud someone else? That's what makes the distinction between a misdemeanor or felony charge on this particular crime, okay? Now, let's say, when could it be a third-degree felony? If it is proven that the government record was a public school record report or assessment instrument required under Chapter 39 of the Education Code, or was a license, certificate, permit, seal, title, letter of patent, or similar document used by the government or by the United States, unless the intent was used to defraud or harm another, in which events the offense would be a second degree. So notice, it elevates it to a third degree if you're using a certain type of governmental record. Now, a third-degree felony is punishable by a minimum of 2 up to 10 years in prison and up to a $10,000 fine. That's a third-degree felony. If you used that particular type of governmental record and you used it to harm with the intent to harm or defraud another, now you're talking about it being elevated to a higher level charge of a second-degree felony, punishable by a minimum of 2 up to 20 years in prison, okay? Now, here's the thing. I'm going to give you one other example. There is a situation where it can be a Class B misdemeanor. All right, how is that? Well, if you present a standard proof of motor vehicle liability insurance form or financial responsibility form, and it is proven to not have been issued by the insurer, then guess what? That's a Class B misdemeanor, okay? So if you have a fake proof of financial responsibility, that's actually a Class B misdemeanor. You can get arrested for it. If a police officer were to see that, you can be charged with a Class B misdemeanor punishable by up to 180 days in jail and up to a $2,000 fine. So look, it sounds like it's a minor thing, right? Like, well, who cares? It's just a piece of paper. Maybe it wasn't exactly right. How is that any different than having a fake ID? Well, it is different. The law prescribes a different type of punishment, and it can have dire consequences because people see tampering with a governmental record as almost a crime of dishonesty. So if you are convicted of this type of offense, it can have dire consequences when it comes to employment options, gainful employment, and just how people see you, your general reputation, okay? Now I'm gonna talk to you for a couple of minutes. What are some legal defenses to the crime of tampering with a government record? When you analyze the code and you take a look at what has to be proven, one of the first things that you wanna look at is you're going to look at to see if the state of Texas can prove criminal intent, okay? Now, I'm going to do this because I don't want to beat you down too much on this, but I'm going to go through and give you the little symbol right here. Every single time I'm wanting to point out the criminal intent element and how important it is. So a person commits an offense if he knowingly makes a false entry. What if it was done negligently? What if it was done not knowingly, but instead recklessly, but it wasn't something that was intentional or knowing? And it says knowingly makes a false entry, and it says also with knowledge of its falsity and with intent. So if you present a record and you present that record, you have to have knowledge that it's false, and you must have intent to make it come off as a genuine governmental record. Okay, so notice, if it's done accidentally, it's not a crime. Okay, or you must intentionally destroy, conceal, remove, or otherwise impair the governmental record in some way with intent that it be used unlawfully. All right, so you had to have made that alteration knowing that it was altered, and it must be used with the intent of passing it off as such. Okay, or another one, makes, presents, or uses a governmental record with knowledge of its falsity, once again, or possesses, sells, or offers to sell a governmental record or blank governmental record form with knowledge that it was obtained unlawfully. So I want you to notice, as I've done that over and over again, you see the words knowledge, you see the words intent, that it be used unlawfully. You must be aware of the falsity of that document, or you must have knowledge that it was obtained unlawfully. All right, I'm going to give you an example. For example, we had a client that had a friend tell him that he needed assistance cashing a governmental check, that he had gotten this check in the mail from the government and needed help because he lost his ID. The story was dumb. Now, the client had no knowledge that it had actually been falsified. He was trying to do his friend a favor. I'll tell you this, the client was very gullible. If you could be guilty of being stupid, he was guilty of being stupid. That was a bad move. The worst thing he could have done was to trust his friend when it was a very sketchy request. But it was foolish, but was it criminal? Well, did he present that governmental record with the intent that it be used unlawfully? Of course, he had no gain from it, right? He was just trying to do his friend a favor. Of course, his friend didn't go in with him to do it. He just sent him in there with him on his own. In fact, you see this happen quite a bit. We actually ran a couple of years ago, we saw someone that actually would pull up in a van and ask someone else, homeless folks or someone else that are out there down on their luck, tell them, listen, if you'll go in and cash this check, I'll give you half of it. Now, maybe you're looking at it saying, who would ever do that? Problem is, they found many, many people that were hurting financially that would do that. They end up getting arrested for the crime of tampering with a government record, okay? Remember, it is the prosecutor's burden to prove beyond a reasonable doubt that you knowingly made a false entry or altered the document with knowledge of its falsity and with intent that it be taken as a governmental record. Failure to prove that element beyond a reasonable doubt will result in your tampering of a government record case being dismissed or you winning and prevailing at a jury trial. All right, now, what if we're talking about the burden of proof? Remember, I told you under our constitutional provisions under the United States as well as Texas constitutions There is a provision that says you or your loved one, if you have been charged with this crime, you have no burden to prove anything. You stand cloaked with the presumption of innocence. I know it may not feel that way, but that's what our law says. So as a result of that, it is incumbent upon the prosecutor to prove that case beyond a reasonable doubt. And so here's the problem. Too many criminal defense attorneys try to hurry up and force something to take place or try to convince their clients to take some sort of plea deal at the very beginning of the case. And what ends up happening is sometimes you have to push the prosecutor. Sometimes you have to allow the court system to progress far enough into the system where the prosecutor begins to realize they can't prove their case. Now, every case is unique, but I'm specifically speaking, if you are innocent and you know you have not done this and did not have the criminal intent to commit this crime, your attorney needs to push that prosecutor, hold them to their burden to prove the case. You don't have the burden of proving anything. Now, one of the things that we do here at the Hampton law firm, I want to provide you a free consultation, a free case analysis. If you or a loved one is facing a charge of tampering with a governmental record, I want to provide you the opportunity to give us a call. Don't hesitate to contact our office. You're going to see the number up here above the screen. It's been on the whole time I've been talking here. I encourage you to click on that or call that number that you see on the screen right above you right now, and we'll be happy to give you a free case analysis and a consultation. And I want to thank you also for joining us today. Remember, I promised you that free ebook. All you have to do is click the link down below in the description section of this YouTube video, and I'll be happy to email you over the free ebook, What to Do If You've Been Charged with a Crime in Texas. If you liked what you heard here today and maybe it was helpful to you, I encourage you to subscribe to our YouTube channel, click the little notification button on there, and like this video, and we'll be happy to send you more great content just like this. Thanks again for joining us. We'll see you next time.